Good afternoon. My name is Aisha Ahmed and I am an employment and discrimination barrister practicing at 42 Bedford Row. I'm going to talk to you today about how to win a social media case, and I hope to give you some legal insights and some practical tips. This is, of course, not a substitute for independent legal advice. The social media landscape looks something like this. There are millions and billions of users worldwide for Twitter, Facebook, WhatsApp, LinkedIn, Instagram, and there are an ever-increasing number of additional platforms. Employees can spend up to 13 working hours a week within working hours on non-work related social media sites, and this is problematic. The problematic side of social media usage is that this can cost millions in lost revenue from cyberloafing. It reduces productivity. There's a risk to employers of reputational harm, which of course can lead to an exposure to litigation when employees are using these sorts of platforms to breach other policies like bullying and harassment and discrimination. There is also a proven negative impact on morale and mood after individuals have been browsing some social media sites. There are, however, positives. These positives need to be harnessed, and they help employers and they are good for business. So employers often encourage blogs and tweets, employees to network within industry. They appreciate that this sort of positive social media use can create cohesion, loyalty, encourage a unified workforce. And so employers use employees as brand ambassadors. They get free publicity, free advertising, they have a market presence, and they like the fact that employees can engage with consumers on these platforms. However, it is always preferable to prevent litigation than to have to actually fight claims all the way to the tribunal. I've identified a number of factors that can assist you in preventing ending up in hot water. The first, of course, is a clear social media policy. There are also available in the marketplace social media consultants who will come in, they will monitor the usage of staff, and they will advise you based on the statistics. Some employers put in place measures like banning the use of certain sites within certain hours. Another useful tool is induction training so that employees know from day one what is expected of them and what the parameters of acceptable social media usage is. These sorts of messages, however, need to be reinforced, and refresher training is very advisable. The training. The purpose of the training is to leave the employee in no doubt whatsoever about what is appropriate and what is inappropriate use of social media. There is a line between the personal and professional, and social media is a particular area where these lines get blurred. And it's often useful to use examples and role play with employees to help them understand where that line lies. Training can also educate employees on the impact of social media on mental health, well-being, sleep, family life, and health and safety at work. These are concepts that are increasingly important to employers because they, of course, affect the working relationship. They impact productivity, and they impact the nature of the relationship that employers form with their employees. It's important that you should get employees to also sign off on that training every year because it should be updated. Now, I have decided to divide this talk into 4 compartments, the 4 C's, and this is my suggested route map on how to win a social media case. The first, of course, is the code, social media code. The second is content. The third is context, which of course is important in most legal landscapes. And finally, case management. Have a clear social media policy. Set out what periods are covered, working and non-working hours, which devices are covered. Employees access social media from a variety of different starting points. They can have a work device with personal content, a personal device with work content, laptops, phones. Make sure you tell them that everything is open to scrutiny in the instance of misuse of social media. Explain to them that they do not have an expectation of privacy, so that later on they aren't caught unaware that they, if they use their work emails to send personal messages, that they may be subject to scrutiny and monitoring. Explain that there is a zero tolerance for any form of discrimination, and set out the organization's ethos, whether it's equality, diversity, respect, tolerance, or a combination of all of those, because this sets a tone. It sets a tone for conduct. And then when employee conduct falls short of it, you are able to point to that as a legitimate aim. If you are having to strike a balance, if you are having to justify an action or explain that what you have done is a proportionate means of achieving a legitimate aim, because your legitimate aims are set out clearly in your policies. Make the critical link between inappropriate use of social media and reputational damage and breach of confidentiality, and critically make the link between misuse of social media and misconduct or gross misconduct or demotion as a likely consequence of that misuse. Have a clear code. This case gives you a clear example of the advantage of having one. It's Crisp versus Apple Retail. The employee here made negative comments about Apple. They were posted on Facebook. And even though his settings were private, a friend reported these comments to the employer, and the employee was dismissed. Now, the Employment Tribunal found that the dismissal was fair because there was a clear social media policy that prohibited these sorts of comments about the Apple brand and products. And the tribunal found that Article 8 did not assist the employee's case. Now, here is an example of a case where there was no code at all. So Faisal Old, a former charge hand for a haulage firm, was awarded £8,000. He was found to have been unfairly dismissed for posting a photograph of himself in a sexually compromising position at work. But the judge found that the firm had no social media policy in place, and he set out some guidance that employers really do need to have not only a clear social media policy in place, but they need to proactively communicate it to their workforce. Now, by contrast to the complete absence of a code is the case of Henderson versus London Borough of Hackney, but the approach is different. Also, there is no code. However, the inclusion manager here mentored vulnerable pupils and was summarily dismissed for using their work computer to view sexually explicit images and videos, and for forwarding them to a colleague at work. However, she defended her actions. She didn't think there was anything wrong with them. And the dismissal was upheld by the EAT, and the Court of Appeal refused permission to appeal, stating that it was clear that conduct of this kind in this context was gross misconduct. The fact that it had not been spelled out as such in the policy did not make it any less grave or gross. Spelling out should not have been required to a person in the employee's position. However, it's probably preferable to have a code in place rather than to rely on something being obvious. Although if you don't have one to argue, then look at the employee, look at the employer, look at the context and make the best case you can. Now I'm moving on from code, which is the first element of the 4 C's, to content. And when you are looking for evidence to present to a tribunal in a social media case, look at the length of time that a post was up, consider who posted it, the number of views it had, how quickly the employee removed it, the relationship to the employer of that post, and whether the employer could have been identified and hence tarnished by association. Was the damage to reputation or brand actual or potential? And that is the case of Nigoli and the University of Sheffield. The second part of content is to look at whether it is criminal, sexist, misogynistic, racist, offensive, in the work context, or simply a genuine expression of views. Now, I have set out 4 classes of offences that may be committed in the social media context that are criminal offences. And it's surprising how many employees are unaware that misuse of social media can actually be a criminal offence. And it's instructive to just consider what these offences are. The categories mirror those identified by the CPS in their guidance to prosecutors. The first is threats of violence or damage to property. The second is harassment of an individual under the Protection of Harassment Act. Breach of court orders. An example is the Contempt of Court Act. If it amounts to conduct tending to interfere with the course of justice, in particular legal proceedings, regardless of the intent to do so. And finally, communications that are grossly offensive, indecent, or obscene. Now, when it comes to content, help the judge. I remember hearing a judge who was a trainer for other judges giving an after-dinner speech at an ELA dinner and explaining that popular slang was something judges needed to have explained to them, because he gave an example of a case where a COO had sent an email after receiving company accounts, and he'd sent this email to the CEO with the subject heading WTF. But the significance of that was lost on the judge because he wasn't familiar with this sort of abbreviation. So state the obvious in witness evidence when it comes to social media, because sometimes those who don't use these platforms are not familiar with the forensic details which are significant in arguing a case. So, for example, in a WhatsApp case, the administrator is the person who can invite people to join and who can remove people from a chat. The text from the administrator is, of course, in a different colour. So it's important to point that out in witness evidence, even though the investigating manager may not realise that it's important to do so. For example, in a case where a senior manager sets up a WhatsApp group, it's relevant that a subordinate is intimidated to leave a site which may be sharing sexist and racist and misogynistic content, because everyone will see him leave the site, the chat, and everyone will think it was a bit of a rude thing to do, given that somebody in a position of authority had set up the chat. So there are permutations that arise from social media usage that need to be made clear in witness evidence. The case of Gibbons and British Council, the court made this point, explaining that they had little practical experience of Facebook use of their own. Now, content, I beg your pardon, is something I'm moving on from. Context. Context is my third C, and this is my favourite quote from Lord Steyne in the case of Daly, ex parte Daly. In law, context is everything. Look at the nature of the employee's work and job and the type of organisation, what the employee's position is within that organisation. Of course, the more senior they are, the higher the expectation will be that they will have insight and judgment into the misuse of social media. Consider the seriousness of the misconduct. Look at the terms of the social media policy. Assess the risk of reputational damage to the employer and the disclosure of confidential information and its impact on the employer, and state what the mitigating factors are if you're for a claimant, the length of service, that contrition was shown at an early stage, that the employee cooperated, provided passwords, produced devices at the earliest opportunity, removed offending posts. Last week, in the Court of Appeal, in Page and NHS, I'm grateful to Jason Breyer's Twitter feed for this very conveniently quoted paragraph, which addresses and deals with two cases, the Smith case and the Ngoli case, and reaffirms the contextual approach that the courts will apply. So in Smith, an employee of a housing trust, of course not at board level, and in Ngoli, a social work student, had expressed their views about homosexuality on social media. There was no reason to suppose that their expression of these views in that way would have any impact on how the public might engage with the relevant services. This is last week, and again, an important reinforcement of the approach. So Smith and Trafford Housing Association was a case involving a Christian manager who said on his Facebook page that holding civil partnership ceremonies in churches was an equality too far. But it illustrates very well the approach the court will take, because they upheld a breach of contract claim against the trust, stating that it was his personal view on his personal Facebook page. It was out of hours, but most importantly, the court considered it moderate, and that a reasonable reader was unlikely to think any less of the trust. By contrast, last week's case with Miss Amuba versus Michael Garrett Associates and Leicester Theatre Trust was decided on the other side of the line. So Miss Amuba was cast in The Colour Purple as the lead actress, and she was a Christian actress at 20. This was in 2014. She had posted on Facebook something which many years later another actor tweeted about. This created a media backlash. This is an extract of what she said. "I do not believe you can be born gay, and I do not believe homosexuality is right. Though the law of this land has made it legal doesn't mean it's right." She stood by her expressions, the expression of her views, and she also said that had she thought that the character was gay, she would never have taken the role. Of course, it was open to interpretation whether the lead character in The Colour Purple could be seen as gay, and therefore her claims for discrimination on the grounds of religious belief, her breach of contract claims, and her harassment claims were dismissed. And it's instructive to see the sort of evidence that must have been before the tribunal, because this is what they said. The effect of the adverse publicity from the 2014 post's retweet, without modification or explanation, on the cohesion of the cast, the audience's reception, the reputation of the producers, and the good standing and commercial success of the production were all were the reasons why she was dismissed. So she was not dismissed because of her religious beliefs. She was dismissed because of the negative publicity and the impact on the theatre and her agents. Now, a third example of how the courts will consider context in cases is Mason and Huddersfield Giants. Now, here, after a match, during a drinking session, a player took a photograph on another player's phone of his private parts. When the player whose phone it was went home, his girlfriend posted it. When he found out, he eventually removed the post, but he was dismissed. The club said that they promoted family values and they didn't need to wait to ask him to remove the post. He had already removed it, but he was dismissed. The dismissal was considered to be unfair. The tribunal considered factors like he didn't post it. He didn't take the photograph. He removed it as soon as he could. And there were other factors, like the tradition of making players who had not scored during that season to run across the pitch naked. And so in the round, there was an evidence before the tribunal that the club had actually suffered reputational damage due to the posting. Now, I'm moving on to the fourth C, which is case management. It is critical that you secure and preserve evidence, like screenshots of offending posts and tweets, and that you retain devices and seek passwords. After preserving data and devices, verify authorship, content, dissemination of data, history, and metadata, because you will be challenged. If you end up in court, these are the elements of evidence collection that will be challenged. Delete as soon as possible after the evidence has been preserved any offending posts, so that you too are minimizing any further reputational damage to your organization. And of course, keep records of the number of views, any complaints that the company or employer receives from customers, any negative communications about what's happened from clients, and lost revenue and lost accounts. This evidence is going to be crucial if you have to prove reputational damage or commercial damage. Now, the second element of case management is conducting a fair investigation. And of course, under Section 98, which applies to social media dismissals, the Birchall test, of course, is the reasonable belief, reasonable grounds for belief after reasonable investigation. So investigate justifications or explanations that have been given by an employee to misuse of social media when they say, well, our passwords aren't individual, we share them, or other people have access to my workstation and my work accounts, and therefore they could have posted the offending material. In the case of Chokski versus Royal Mail, this is precisely what the employee said, and the employee was actually ultimately held to have been dismissed unfairly because he claimed that the pornography that was uploaded to the employer's server wasn't uploaded by him. It's also important when conducting an investigation to give an employee proper access to the material in question. Now, quite often employers are very sensitive because the material that they're handling is sensitive, and they sometimes refuse to give access to an employee. But this should be avoided because in order for them to provide a proper account, an explanation of what has happened, they need access to the material, however sensitive it is, and no matter what the volume. If you do not want to increase the number of copies of the documentation in circulation, then invite them to premises where they can have unrestricted access, but in a controlled setting. Now, there is no magic formula for social media cases. The existing tests are sufficiently flexible. The first Scottish EAT case that dealt with Facebook held that Facebook didn't require a new set of rules, and ordinary principles of law applied to social media cases. Again, in game retail and laws, the court refused to provide general guidance because it said that the tests that were laid out in case law, cases like Iceland and frozen foods, were sufficiently flexible. All cases in the social media context are fact sensitive, and the courts discourage a checklist approach to unfair dismissal cases. There is a broad test for what acts are considered to be in the course of employment for which employers are liable. So in Jones and Tower Boot Company, the conduct included that was outside the workplace, and jokes that were posted on social media about other employees were likely to be found to constitute harassment, making the employer liable. In Otomewu and Carphone Warehouse, sexual orientation harassment was found against Carphone Warehouse after a colleague's Facebook account was hacked. Now, as far as reasons for dismissal in social media cases, it's quite often misconduct, can also be SOSR, as the cases of Riley and Sandwell and Gibbons and British Council show, where there is a particular lack of judgment and insight shown. It's explained quite well under the umbrella of SOSR. In Riley and Sandwell, a head teacher was in a relationship that she'd failed to disclose even after the person she was in the relationship with was convicted for having images of children, sexualized images of children. And this was not disclosed by her to the board, and she didn't think that there was an obligation for her to disclose this. In Gibbons and British Council, the employee made rude and derogatory comments about Prince George, and these were, she claimed, because she was a Republican, and it was her belief that entitled her to make these statements. However, the court felt that she was a senior employee and that she knew that her comment would be deemed unacceptable, and her actions amounted to reckless risk-taking. There is then the third potentially fair reason, which is performance and capability, which statistically is possible to show excessive use, missed deadlines, lack of client care, and social media can trigger, or misuse can trigger, performance and capability issues and dismissals. And then sickness absence, where posts on Facebook and Instagram show that an employee, rather than being chained or confined to their sickbed, is actually on holiday or down the pub. Now, privacy. Is there a reasonable expectation that employees should have that they send personal emails and that those should be not looked at? or not scrutinised by employers? Well, in Atkinson versus Community Gateway Association, a director was having a relationship with a colleague and sending sexually explicit emails on his work emails. And even though he had drafted the social media policy, he had not marked them personal and confidential, and the employers looked at them as part of a disciplinary. And of course, whether or not there is an expectation will depend on the facts of each case, but it wasn't found, it was found in this case that the employee did not have the expectation. Now, what the settings are on an individual's Facebook account or Twitter account, whether they're private, whether they're public, that is a factor that, whilst is often looked at, it is not determinative in itself of the outcome. So each factor, each case will be made up of a variety of different factors, and the privacy settings is simply one of them. Now, human rights challenges in the social media context are often in the form of two articles. Article 10, which is the freedom of expression, and Article 8, which is the right to respect for private and family life, home, and correspondence. Both rights require balancing. They are qualified rights if the interference is in accordance with law and necessary in a democratic society, and for the protection of rights and freedoms of others. So in the case of Page and NHS Trust Development Authority, Mr. Page was non-executive director of the trust, but also a magistrate. He expressed his views that he did not consider it normal for a single parent or a homosexual couple to adopt a child. And he thought that his religious beliefs were engaged, and he also failed to tell his employer, the trust, about the fact that there was media scrutiny of the fact that he had made such a declaration as a magistrate and been reprimanded for it. Now, Article 9 of the ECHR is qualified by 9.2, and such limitations prescribed by law and are necessary in a democratic society in the interests of public safety, for the protection of public order, health, or morals, or for the protection of the rights and freedoms of others. So the tribunal found that even if Article 9 was engaged when the health, rights, and freedoms of others meant that limitations would have applied, importantly, the trust was also subject to the public sector equality duty under Section 149 of the Equality Act. And these factors could have been very important had the trust needed to rely on their defence of objective justification. So when setting out one's legitimate aims, factors like the public sector equality duty are important to bear in mind. Now, the Human Rights Act and employment tribunals, X and Y in 2004 held that the Human Rights Act applied to both public and private employers. And if the ECHR is triggered, then there is a positive obligation to safeguard the right and consider whether the interference is a proportionate means of achieving a legitimate aim. In the case of Henderson and London Borough of Hackney, the employees' arguments based on freedom of expression under Article 10 were rejected. The court held that even if Article 10 were engaged, which of course it didn't decide, this would not have been the most profound interference with freedom of expression, and the interference would have been justified and proportionate for the protection of health and morals. So there will be a balancing that is exercise that is carried out, and this is further illustrated in the case of Hebei and Hungary. The court held that there had been a violation of Mr. Hervey's Article 10 rights, since the Hungarian court had failed to carry out the requisite balancing exercise between the individual's right to freedom of expression and the employer's right to protect its legitimate business interests. They therefore did not discharge their positive obligations under Article 10. Now, you'll all recall another case that illustrates this balancing exercise, and that's the Barbalescu and Romania case, which, of course, originally was found to have been not in interference with Article 8 because the ECHR considered that monitoring of the employee's internet usage and the use of Yahoo messages in disciplinary proceedings was a proportionate interference with that right, and that it wasn't unreasonable for employers to seek to verify usage during working hours. However, the Grand Chamber of the European Court of Human Rights has reversed this finding, holding by a majority that the employee's Article 8 rights had been infringed. So it was found that the Romanian courts had failed to strike a balance between the relevant competing interests. There has been in recent years a blurring of the public and private. So there's a widening of the traditional definition of private life, and it seems to be ever widening. And this does mean that it's likely that tribunals will have to carry out their own balancing exercise rather than just review whether the right is engaged. This might be preferable to Denisov and Ukraine, that type of approach, which is restricted to particular cases where serious detrimental impact on private life, relationships, or reputation has to be evidenced. The future. The range of reasonable responses test has been the bedrock of unfair dismissal law for 40 years. Lady Hale raised the proverbial eyebrow at it and stated that experts in this area seem content that it's fit for purpose. That's in Riley. It is fit for purpose. However, I think it is flexible enough to withstand development. A dismissal falls outside the range of reasonable responses if the tribunal considers that any infringement of Article 8 or 10 is not a proportionate means of achieving a legitimate aim. This is one possible development that could keep in place and in play the reasonable responses test, but make it more amenable to a balancing exercise when human rights are engaged. There's no harm in getting in the habit of drafting aims into policies where human rights are likely to be engaged. Plead your aims and show that the actions taken constituted the least intrusion to the right, procedurally and substantively. I'd like to move on to some questions. Thank you very much for listening. Hello, thank you everybody who joined. I have some interesting questions that are showing up in the Q&A box. And I also have had emailed to me some very interesting questions, which I think will have a wide audience because they apply across the board and are quite often the sorts of things that most people would like to know. So I'm going to start with the first question in the Q&A box, which is, what about a policy that says you should not post anything that anyone finds offensive? That, following Negoli and Smith, is surely far too vague and the bar is too low. Well, you will have seen from my presentation that I've referred to both the cases of Smith and Negoli in the context section with reference to the fact that the court is going to look at how mild, how moderate, or how extreme the content is that they are dealing with. And so in Smith, of course, the court held that it was a moderate expression of views. And in Negoli, in fact, the Court of Appeal criticised the university because they held that actually it was the university that showed a lack of insight. First of all, they misunderstood their own code. I think they were dealing there with the HCPC, which is the Healthcare Profession Council, and they exaggerated the terms of that. And therefore they gave no explanation to the student who had, for those of you who aren't familiar with the Negoli case, he had expressed his views on Facebook and then had been sort of dobbed in by another friend on Facebook. And he had used words like abomination and wicked, but it was, he was quoting directly from the Bible, and he stood by the fact that he was entitled to quote from the Bible, and those were his religious beliefs. But what the Court of Appeal did analyze in detail was the fact that the university didn't explain to him that it was the manner of expressing those beliefs that was problematic, not the fact of expressing them. And so what I find happens quite often is that employers have a knee-jerk reaction to an incident that involves a breach of social media, and can quite often go to extremes and therefore choose a course of conduct that then later on gets them in trouble. So a policy that is entirely sweeping and covers any offence to anyone is probably not going to be found to be reasonable. Also, Section 26 4C of the Equality Act, which deals with harassment, does consider whether it was reasonable for the conduct to have that effect. So this is in the instance of the definition of harassment, which of course is unwanted conduct related to a protected characteristic that has the purpose of violating a person's dignity or creating an intimidating, hostile, degrading, humiliating, or offensive environment for that person. So even if the person who has made the post doesn't intend for that conduct to have the effect, if it does, but if it's considered reasonable to have that effect, then it'll be found to have breached Section 26. So there is always a balancing exercise that the court, the employment tribunal, will undertake. So I hope that answers that question. And then I've got a second question, which is, what rights does an employer have to tell an employee to change their LinkedIn details? Well, I think the LinkedIn user agreement says that whoever is the named user has control over it. So an employer can't order delivery up of that account or the password. However, it's known that employees will continue to post past experience and past employment history on it. But if an employee is misrepresenting their current employment status, then I suspect a polite letter to them will be a good starting point. As far as what further legal action you can take, I don't think that you can actually take them to task and force them to remove a post if the user agreement is in their name. Now, I've been asked a broad general question, which I thought would interest everybody, and that is, it's from a medium-sized employer and owner of business, and what they'd like to know is that how can I control content on employee WhatsApp chats? Now, this is something that comes up very often in this area, and there are two parts to that question, because the person has also pointed out that aren't these WhatsApp chats encrypted? So I'm going to take that question in and answer it in two parts. The first, of course, is that as an employer, you must know that you can be held vicariously liable. And those are for any acts that take place or comments that are made on social media in the course of employment. And of course, in the course of employment, stretches to social gatherings, parties, Christmas dues that are held, but they also extend to work WhatsApp chats. So if there are comments made outside of working hours on personal phones, but it's a work WhatsApp group, then the employer is potentially liable, vicariously liable for what might be discrimination or harassment. So it's very important that employers set out clearly in their codes, as I've spoken about already, what their expectations are. GDPR is also engaged because if you want the right to go through employees' social media usage on work phones, for example, then you've got to have that information. You've got to make that very clear to the employee, that you will be doing that you will be monitoring phone use, you will be looking at work devices and social media applications on those devices. Now, the end-to-end encryption is often something that comes up, and it's the second part of this question. Often claimants will say, or employees will say, well, it's private, it's encrypted end-to-end, and so there's no risk of reputational harm to my employer. That's a misunderstanding to some extent of the point of the end-to-end encryption. What it protects users from is hacking. Now, it's unlikely that an employer is going to be hacking into a WhatsApp group chat, but consider the ways in which these matters come to light. It's often whistleblowing, which is often somebody else on that chat who finds the content to be difficult or inappropriate, and therefore plucks up the courage to go and tell somebody about it. Or it is because somebody who is on the chat has been bragging. Often there is a lot of bragging about jokes that are aimed at employees, often female employees, and so the person who has been told about the WhatsApp group chat will go and inform a manager that this exists, or instances where an employee's handed in an old phone and this has come to light, or there's a case of PC David Alston where the phone was seized, his phone was seized as part of another criminal investigation, and lots of pornographic material was discovered on his phone, and of course this was considered to be problematic given his position in the police force. So end-to-end encryption becomes irrelevant when you're defending your position or your posts on a WhatsApp group chat. It often is the case that when cross-examining individuals about content, they will say things like, well, yes, I might have been rating women at a work conference, but I was showing my wife and she found it funny and it's all in good humor, or I was showing my teenage son. And of course, the very obvious follow-up question is, well, then the encryption is irrelevant, isn't it? Because you were willingly showing your phone to other people, and no doubt did you impress upon them the need for this, whatever you showed them, to remain entirely confidential? And of course, the answer is no, they hadn't. So that's, I think, an important qualification to make when one's thinking about how safe these chats are. And then there's a second question which I've had emailed to me, which is about whether highly sensitive material and offensive material, when it appears as the subject matter of a case, can be kept confidential and kept out of a tribunal judgment. This is a very interesting area, because the short answer is not really. So if you are a claimant and you are bringing a challenge to a dismissal or a demotion in the employment tribunal, and you are not contesting that you have posted certain things, or you are not challenging the fact of having made certain contributions to social media chats, then you must be advised by those instructing you, or you should research that all tribunal judgments are going to, well, since at least February 2017, posted on a government website, and everyone can potentially Google those judgments and read them. And tribunals are reluctant to remove details from judgments, even in cases like disability discrimination claims, where a claimant, for understandable reasons, might be embarrassed for very private details and personal details of disability and the impact of that disability on them to be redacted or removed from the reporting of a judgment, because the tribunal thinks that removing the details of a judgment are going to remove an important context and important reasoning within the judgment, and therefore the judgment's going to be less easily understood. So whilst in rare cases tribunals might remove the names of a party, they're very unlikely to remove the names of a party in a case where there's offensive material, and you probably don't want future employers to be able to Google and see what you've been up to. Also, it's a public hearing, which means if it's a final hearing, particularly, any member of the press can come and report, and you are open to that sort of public reporting. In addition to that, there's interesting case which, if you want to look into the balancing act that the tribunal will carry out between the aim of having open justice and your ECHR right to privacy. It's the case of LVQ, which involved somebody who was suffering from a disability. Now I can see that there is another question that has come up, which is, does it matter if the person who has been the subject of the ridicule or the jokes on a chat doesn't know that they have been talked about or ridiculed? The short answer to that is no, it doesn't matter. In fact, there's a case called Mr. Case and Tay Tarian. It's a 2018 case, and it was a Welsh housing officer who had set up a WhatsApp group chat originally to catch up with an employee who was, or stay in touch with an employee who was on sick leave, but it eventually turned into a group that targeted another colleague. They called her autistic. They made fun of her personal hygiene, and she was not invited to join the group. Now that's also, of course, a problem, the setting up of groups which are excluding one person in particular. And so the fact that she didn't know, the judge didn't think that that was something that stopped him from finding that there had been a breach of Section 26. Now, it's a two-edged, double-edged sword. So the CIPD had a survey of employers, and the results were quite interesting. So 26% of employers thought that WhatsApp encouraged collaboration, but 40% thought that it undermined corporate culture. And so really, I think employers have to educate employees about the fact that because the setting is informal, people let their guard down. And they seem to think that because it's on their phone, it's uh, not going to be open to scrutiny. But it's no different than going to the pub on a Friday night and being overheard by somebody. In the context of, I've got a question that has been emailed to me about using social media and posts as a defense to challenges following on from COVID and coronavirus, where an employee is saying that there are imminent risk of coming into work, and therefore they're concerned for their health and safety, and they're going to stay at home, and that the employer cannot force them to come in. That it's no different to a situation where an employee is saying they are bedridden, and you do your old-fashioned detective work and look at all sorts of information. So in that sort of a case where an employee has been off for a year and is claiming that they have been bedridden, of course they've also got a company car, and a simple question of who drives the car and who's insured on it says the answer is, well, it's just me, but the mileage is thousands and thousands of miles, so they couldn't possibly have been bedridden, so they're probably making up the fact that they were unwell. And in those sorts of cases, of course, if you are challenging disability status, you will win. No different. So this context, using social media evidence to make those sorts of arguments, it's no different. So an employee who is saying that they're absolutely terrified of coming into work, even when measures that comply with government regulations have been put in place, and you have a colleague who comes and says to you, well, they've been taking part in group gatherings of 20 people in the park and picnics, and are perfectly comfortable coming to see people, and have been leaving their home for other purposes, non-essential purposes of a nature that involves socializing with work colleagues, then it's going to be a little bit harder for them to establish that they did actually feel like their life was in danger and they were in imminent danger. So social media can be used evidentially in the same way as videos have in the past, or in the same way as recordings have in the past. But we have used, people in the employment tribunal arena are familiar with employees pressing record on their iPhones and then producing transcripts of those recordings. And often the test is, courts of course aren't particularly keen on those sorts of covert recordings being produced, but ultimately the test is whether or not it's relevant to the issues that the tribunal has to find. And quite more often than not, those recordings are allowed in if they are relevant. And the same applies to social media evidence. If it's relevant to the issues in the case, then it's more than likely going to be allowed in. Now I have another question that's come in the Q&A, which is, I was wondering how the balancing act may occur in an event if an employer has political affiliations with a rather problematic party, example, a right-wing party that promotes Islamophobia, would simply reposting the party's mandate open an individual to a potential lawsuit? Well, of course, we are dealing here with the employment context. So, of course, the rights engaged would be the rights to have a political belief, and so in the case of Gibbons, the political belief that was being claimed was republicanism. But of course, it's it's the extremity or the extreme nature of the post that is going to be called into question. And so if the post involves, when you say Islamophobia, if it's inciting violence, then it could potentially be a criminal act. I think I took you in the talk through 4 potential criminal acts that can flow from social media misuse, and those that involve causing physical harm or property damage to individuals purely based on their religion or belief is likely to probably be a criminal offence, in addition to being problematic in the employment context. I'm going to just see if there's anything else that has come up. No, I think we are at our hour's cutoff point. I'm really grateful to all of you who have signed in, and thank you very much for sending in your questions. And I hope very much that you have found the talk today to be useful. Thank you.